Hi, everyone. So Carol asked me to answer a few questions that we didn't get to in the original recording. So I think the first one I will tackle is the idea that if a Republican wins, we're going to end up with a Congress that can ban abortion. That's absolutely absurd. Even if the Congress were all Republicans, they could not ban abortion for a number of reasons. Number one, remember the Supreme Court said this is a states' rights issue. That's like declaring Congress has no authority to act. Number two, the Constitution has always been clear that Congress has no authority to act unless the Constitution gives it authority to act. And all other rights are reserved to the states. That's the way it's been set up. The national versus the state governments have always been Congress has limited rights, the states have everything else that's left. And in order for Congress to act, either in terms of codifying or banning something, they have to find a source in the Constitution that gives them authority to act. And before Dobbs, they could have at least argued that they had authority to act because the Supreme Court said that the right to abortion was constitutionally rooted, which at least implicitly gives Congress authority to act because the source for the rights was in the Bill of Rights. And generally speaking, Congress has authority to act in furtherance of rights under the Bill of Rights. I'm overstating it a little bit, but generally speaking, when the federal Constitution creates a right, Congress, generally speaking, has regulatory authority. Not entirely, but it's at least got to be in there. It's at least got to be in there. So in Roe in 1973, the Supreme Court said women had a right to abortion, and it was this privacy right that was created from an understanding of a variety of rights in the Bill of Rights, including the Fourth Amendment and 14th Amendment and so forth, that privacy was so fundamental that it appears in lots of places in our constitutional rights. And therefore, not only do women have a right to abortion, that it's a really important fundamental right of such magnitude that you have to have strict scrutiny review. That's the way it was in 73. That changed a bit in 1992 with Planned Parenthood versus Casey, where the Supreme Court bumped it down from a fundamental right subject to strict scrutiny down to a constitutional right, but not a fundamental one. Therefore, no more strict scrutiny, but it got bumped down to what's called undue burden review. So you didn't have to satisfy the very rigorous requirements of strict scrutiny. It was enough to just show that there was an undue burden in terms of state restrictions. So after Planned Parenthood versus Casey, states had more power to restrict, not prohibit, but restrict abortions. And as long as they didn't impose an undue burden on the right, then those would be upheld. And again, this is sort of under the due process argument, not so much equal protection, but the 14th Amendment, of course, has both provisions, but the court's focus has always been on due process, liberty interests, autonomy, privacy, these kind of basic rights of self-determination and control over the self, control over the body. So once Dobbs happened, any fundamental right, any constitutional right, any basis in the Constitution for a woman having a right to abortion was taken away. And therefore, what was also taken away was any potential argument that Congress would have that because it was a constitutional right, they had authority to regulate either by banning or codifying. That's gone. Now, some have argued that since all of that stuff is gone after Dobbs, that Congress probably could still find authority to act under the Commerce Clause, perhaps, maybe the Necessary and Proper Clause. These are very abstract, kind of unusual. Well, Commerce Clause isn't so unusual, but to argue that there's a Commerce Clause authority for Congress to act in regulating either banning or codifying abortion is really a wild stretch. And I haven't seen any constitutional scholars persuade anybody that this is a real authority. And I've watched, I've read, and most scholars that I've paid attention to agree that Congress can't ban or codify at this point, and that a Commerce Clause argument means that abortion has a substantial impact on interstate commerce, and it doesn't. It just doesn't. It's you could argue, well, the medicines might be sent from state to state, or a woman might cross state lines to go get one. That doesn't give that's not enough to rise to the level of abortions cause a substantial effect on interstate commerce. They don't. It's just not at all. It's not even a close argument. Which is not to say women won't cross state lines to get an abortion, but that's a different question than whether, because women might cross state lines, it becomes an interstate commerce question that Congress itself can regulate by banning or codifying. They can't. With the ERA in place, there's a guarantee that abortion will be protected. And if you read the Pennsylvania Supreme Court's decision from January of this year in the Allegheny health case, you'll see how the analysis goes. I won't belabor it. I think I went through it with Carol, but Allegheny is a really important case because it used a state ERA to not only uphold abortion rights and prohibit abortion restrictions, it did so under a state ERA that reads almost exactly word for word like the federal ERA. And both in terms of saying this is a much more generous constitutional right than even a protection against discrimination. Like, this is an affirmative right to equality and not just a prohibition against discrimination. And in that sense, it's a much broader right. The ERA is more powerful, it's broader, and it tolerates far fewer encroachments, including encroachments that might inhibit a woman's ability to access abortion even a little bit. So, it's just such a powerful, the ERA is so powerful. And the other beautiful thing about the Allegheny case is that it describes the nature of abortion as a sex-based interest without any doubt whatsoever that this is about women and sex-based rights. And the court is almost mocking in the way it rebuffs any suggestion that abortion isn't about sex-based discrimination or sex-based activities. The court just says it's sort of the quintessential sex-based thing. The ability to reproduce is sex-based, period. Like, they barely even want to debate it because they think it's so self-evident. But it's important because it's only the ERA and the language of the ERA that takes them to that place. Had this just been analyzed under an anti-discrimination provision, the Supreme Court of Pennsylvania might have come to a less strong feeling. They might not even come to the same result, but it was that powerful language of the ERA that got them there. And again, it mimics the language. It's almost word for word the language of the federal ERA. So we know that the federal ERA is broad enough because it's broader even than the 14th Amendment, much broader. And so will cover not only abortion, but also even things that have a disproportionate impact on women and women's lives. Broader in that sense because the 14th Amendment doesn't capture disparate impact cases. The ERA does, or at least in theory does, because it is broader. In order to be broader, it has to do more. And those are the two restrictions from the 14th Amendment that the Pennsylvania court acknowledged. Like, this is the ERA, so sex-based is clearly covered, even though the 14th Amendment might disagree. As the Supreme Court said in Dobbs, this abortion is not sex-based. Well, under the ERA it is. And even though the 14th Amendment doesn't allow disparate impact arguments, well, the ERA is broader, so it does. And this is the wonderful thing about the ERA. It's as broad gets when it comes to protecting women and protecting women in regard to sex-based rights and protection against sex-based harm. So the other important thing I think Carol wanted me to talk about was whether the ERA would affect Holly Lobby. My understanding, and I'm not an expert, but let me just tell you what my thoughts are. I think under the ERA, Holly Lobby would have come out the same, but the reason is they applied a strict scrutiny standard. And, this was about whether employers can deny coverage for contraception. And the court said, well, when you have a religious belief about contraception and you're a religious company, you can make religious-based decisions about the insurance you provide to your employees. And the point is that companies can discriminate if their religion requires discrimination, even under the very most rigid standard. So least restrictive means was the standard they applied. That's the strict scrutiny standard. So I don't think it would have come out any differently. Religious liberty, sadly, is a special place in the law where you can discriminate, even though if you didn't do it in the name of religion, you couldn't. And so because it was analyzed under the least restrictive means test, which is a strict scrutiny test, my sense is that the result would have been the same under the ERA, even though the ERA was not applicable. So, and I'm not even sure they made an equality argument in Hobby Lobby. I think they did. Again, I'm not an expert, but I just want to be clear that because they applied the equivalent of strict scrutiny, which is really what women get under the ERA, I'm not sure the result would be different. Reasonable people, I think, can disagree, but religious exemptions are sort of scary. You know, it's almost like if the KKK became a religion, could it get away with what it does? And I don't know the answer to that. I don't know. I just think you shouldn't be allowed to discriminate just because your religion tells you to. But the reality is we live in a world where it does. And you know, it is what it is. It's the best I can offer up on that. With the ERA, I already went over the Dobbs decision. The ERA would have prevented Dobbs in this for exactly the reasons the Pennsylvania Supreme Court discusses in the January 2024 case, Allegheny case from the Pennsylvania Supreme Court. Would O.J. Simpson's case, Bill Cosby's cases, et cetera, have come out differently if the ERA were in place? This is a really interesting question. I think the answer is potentially yes, because there would have been a place for stronger arguments to be made that the decision-making process needs to be cleansed of sex discrimination. If you know anything about especially how the criminal justice system works, jurors are routinely subjected to screening protocol to make sure, especially if the defendant is Black, to make sure that they aren't racist when they sit in judgment in a case where a person of color is involved, especially as a defendant. And, you know, that's really important. But if the jury is then sitting in judgment of a woman victim of violence, or for that matter, even if she's a defendant, there isn't a similar requirement that sex-based discrimination be addressed in terms of screening out jurors who might make their decision based on discriminatory ideas about women. So, you know, the O.J. Simpson case, for example, there's no question that jurors were screened to make sure they wouldn't be racist, but there was no effort made to make sure they wouldn't be sexist. Now, does that mean the result is based on sexism? No, because I think there was more going on in that case. But let's assume a juror from that case came out and said, well, you know, we don't like women anyway. I just don't care for women. I think they're terrible people. We don't really mind that OJ killed a woman. You know, if someone said that, it wouldn't be wrong. You're allowed to be biased against women because women aren't entitled to equal treatment under jury screening laws at all, ever, either in their capacity as victims or defendants. That second-class status leaves that space within which the government can discriminate. And the government, of course, includes the processing of legal cases in the courts. You know, here's the ERA and here's where women are. And all that space in the middle is where you can put juries in place in all kinds of cases who could openly declare that they're biased against women, and then a woman is involved in the case in some fashion, discrimination against her could take place openly. And it wouldn't be illegal, even though it would be illegal if it happened to another person based on their protected class status. So that second class space is where all the permission resides for the maltreatment of women in every court case, in every single court case. You can't help it. When the Constitution permits discrimination against women is going to happen by the government in all aspects of what the government does, in all branches, by all officials, at all times. Sex discrimination is allowed. Doesn't mean it's always going to happen, but it can. Or as Justice Scalia said, sorry about that. As Justice Scalia said in 2011, it's not that the Constitution requires discrimination against women, it's that it doesn't prohibit it. And that's the point. Discrimination against women is allowed because it isn't prohibited. And that has an impact on all aspects of government, including the courts. We sometimes forget that the courts are the government, but they are. So yes, I think those cases would have come out differently because there would be a sense among everyone involved that it would be unfair and or unconstitutional to judge the women involved in those cases unfairly. The other way that I think the Harvey Weinstein case would have come out differently is that he would have been charged with a hate crime, as would Bill Cosby have been charged with a hate crime for the numbers of women that they offended. If you show a pattern of targeting a certain person because of who they are, you should be charged with a hate crime. But the prosecutors didn't feel compelled to charge either Cosby or Weinstein, sorry, with a hate crime. They would have if those men had targeted any other category of people, but they didn't feel compelled to treat women the same, even though hate crime laws capture women in both jurisdictions where those crimes mostly happened. They didn't charge them because they felt like they didn't have to. It's okay to treat women differently and worse, therefore not charge a hate crime, even though this was a hate crime, and even though women are covered in those jurisdictions, because it's okay to treat women worse. Now, had they charged them with a hate crime, among other things, Harvey Weinstein's case would never have been overturned by the New York Supreme Court, New York State Appellate Court, I should say, on the grounds that it was unfair to let a few other women who he abused testify as supportive witnesses, so-called prior bad acts witnesses, in support of the victims that were involved in the charged crimes. It would have been not only admissible, it would have been required. It would have been required that they charge him with a hate crime, and it would have been required that they allow those other victims to testify, because, I mean, this is so obvious, because when you charge someone with a hate crime, you have to show that they have a pattern of targeting women. So not only would it not have been the basis for overturning the conviction, it would have been ridiculous for the judge to even talk about not letting those other victims testify, because the prosecutor had to show the pattern. This is why hate crimes are so important, and it's why charging hate crimes is so important. But unless women have equal protection of the laws, including hate crime laws, it's okay not to charge, which means it's more okay not to put in those patterns of behavior and so forth. The ERA absolutely would have made a huge difference in those cases. Okay, last question here is the Women's Bill of Rights. It would be counterproductive because of the inclusion of intermediate scrutiny. Yeah, duh. I don't know how else to answer this question. Any statutory codification of intermediate scrutiny is equivalent to codifying slavery, 3 days a week for Black people, not 7 days a week, but 3. I mean, that's really what intermediate scrutiny does. It creates this massive codified permission for the government to discriminate. Intermediate scrutiny is the expression of second-class citizenship for women, because it's less than strict scrutiny. Now, we've already talked about why intermediate scrutiny will never protect women in terms of ensuring that they have separate spaces if necessary for privacy and safety. Because remember, even under strict scrutiny, if a woman needs a separate space for privacy or safety, those things are unrelated to discrimination. So they fit under strict scrutiny. You can justify the separate spaces for women under strict scrutiny. You don't need intermediate scrutiny because those things, privacy and safety, are transcendent. They don't involve discrimination. They are social concerns of their own merit, worthy social concerns of serious consideration, by the way. Safety and privacy have always had very strong support in the law. That more than adequate to justify the compelling state interest standard and to say, look, it feels discriminatory to have separate spaces for women, but it's necessary. It's a compelling need because we need to keep women safe and because naked body parts, this nature of privacy that we've always protected in a lot of different areas of law, is a compelling state interest. The importance of not forcing nudity on people is a thing in this country that we've always had in the law. So it's a compelling state interest where we are willing to protect under strict scrutiny. We don't need intermediate scrutiny to do it. So codifying intermediate scrutiny, even though some people will argue, well, that's where you get the space you need to have separate spaces. First of all, that's nonsense because there are absolutely going to be intermediate scrutiny cases where judges will do whatever they want when it comes to this separate, so-called separate space. But what you want more than anything is that baseline of equality within which you then get to argue about other things. So saying we need intermediate scrutiny across the board for all things that affect women means, among other things, we want women to be beaten, raped, and killed at very high rates because at least we can have a separate dressing room. No, you don't do that. You don't create the space within which men can kill women at very high rates because you think that's the only way you can get protection for a separate dressing room. No, what you do is argue that safety and privacy are compelling state interests, which they are. There's a lot of stuff already out there that says those things are compelling state interests. So you don't need intermediate scrutiny where the compelling interest gets bumped down to important state interest. Those things are compelling state interests, and you don't get more protection because you've decided to bump it down, the category down to important state interest, which is the intermediate scrutiny standard. If you already know that it's a compelling state interest, why would you bump it down to important? And moreover, why would you lower the standard for everything else? At what cost? At what cost are you willing to have that standard be so low that enormous amounts of discrimination are tolerated in exchange, more harmful things are tolerated in exchange for protection that you would have anyway? You would have anyway under strict scrutiny. So codifying intermediate scrutiny is really tantamount to saying to Black slaves in the South, we don't want you to be free. We have concerns that if we liberate you with the 13th Amendment, you're going to get killed, you're going to get lynched, you're going to get beaten, and all of those things happened. All of those things happened. But imagine saying to Black people that in order to keep you safe, we're going to keep you enslaved. We wouldn't do that. We wouldn't do that because there are more effective ways to keep people safe without making them stay enslaved as the price for safety. We would never say that. And nor should we. I mean, there were a lot of Black slaves who said, please don't free us. We're scared. We want to be protected. We feel safe on this plantation. We don't want freedom. We want to live. Don't liberate us. We enjoy being enslaved because it's safe. We said, you can't choose second-class citizenship. It's uncivilized and anti-democratic. And moreover, it's not going to protect you. Slavery doesn't protect you. So I think we have to remember that lesson, but also remember that codifying intermediate scrutiny is, and calling it a mechanism to ensure protection, is really wrapping subjugation in the language of benevolence, which we see in so many other circumstances where, women don't call the police when your husband beats you up because you don't want to support incarceration. That's fascism. You need to, not call the police because you don't want to be a fascist. You want to support decarceration, which is, this wonderful, loving ideology. Hell no, you don't want to support decarceration if it means you're going to live in a violent home. No, you won't do it. Even though decarceration has this benevolent feel to it, and people feel compelled to support it, especially Black women who are under a lot of pressure not to call the police when they get beaten by their husbands. Oh, I don't want to put my husband in jail because he's a Black man and we know that the system is so racist. Well, yes, but your well-being matters. And you don't subjugate your life and your well-being and your safety to someone else's concerns about, disproportionate rates of Black men being in prison because your husband should be in prison. Now, I'm not saying incarceration is the solution to all things that ail us. But what we do know is that people go to jail for doing bad things, and they ought not go to jail just because they chose to target a woman. If everyone else is going to jail for less bad things, let's not keep men who hurt women out of jail and pretend that the reason is because we're all very benevolent and supportive of decarceration when we don't support decarceration for other stuff. We don't support decarceration for all these other crimes. Bank robbery, no one says decarceration for bank robbery. No one even talks about decarceration for bank robbery. We mask our subjugation of women, including our desire to be able to beat and rape and kill them with impunity, by saying, well, this is all about decarceration and being civilized and not being fascist regime. And no, you don't tell women not to call the police when their lives are at stake on the theory that calling the police is somehow bad for humanity. It's very good for her humanity. And there's a lot of data that shows a strong law enforcement response to domestic violence saves women's lives. There's an enormous amount of data on that. I've actually written a brief on it and glad to share it. But I mean, the data is overwhelming that women's lives are saved when there's a strong law enforcement response. I mean, you don't ever want to deter women from asserting their right to seek redress for their grievances, which includes when somebody beats them up. But for women's inequality, women would have an expectancy that they will be treated with equal respect when they call the police, that nobody will pressure them not to call the police, that they will have the harms they endure prosecuted and punished on par with the harms other people endure. But we've acclimated women to expect violence against them to be treated as second-class harms because we've acclimated women to see themselves as second-class citizens. In codification of the intermediate scrutiny standard simply legitimizes that second-class space for women and makes them accept it as better for them. Because, whatever it is that somebody thinks comes with intermediate scrutiny, which I think is 100% false, there's absolutely no basis for the argument that intermediate scrutiny is good for women. And I can argue, and I did argue in this recent piece that I wrote called Constitutional Terrorism, which is about women's status as second-class citizens. I wrote a lot about why this is a false argument that intermediate scrutiny is good for women. And I'd be glad to share my piece with you. But I just, I'm not very tolerant of people who would argue to Black people that they should stay in second-class citizenship and remain enslaved because it's better for them, when I think everybody knows that equal treatment under the law is the only way women will ever stay safe. The mandate that they be treated equally and equally protected under all laws is the way they stay safe. Intermediate scrutiny guarantees them unequal treatment under all laws, and that's how they remain unsafe. It's just not even a close question And of course, I challenge people to a debate anytime. And I also think they should reveal their funding sources and show that there's anti-feminist money behind much of this rhetoric. It may have worked for Phyllis Schlafly a million years ago, that women should enjoy their subjugation and feel protected in it. We're not stupid people. We are absolutely not stupid people. And we have to remember that without equality, without the ERA in place, every law we pass is enforced differently and worse when applied to a woman. Well, I shouldn't say it always is, but it's subject to different and worse enforcement on behalf of a woman. And in that sense, every law we pass is like pushing it around on an empty plate. You pushing crumbs around and they just fall through the cracks. No matter what laws you pass, it could even be a law that says women shall be treated equally under the law. You could pass a statutory law that says women shall be treated equally under all laws. But because it doesn't have roots in the Constitution, even that law that promises equal treatment, because it's a mere statutory law without roots in the constitutional guarantee of equal enforcement, is subject to unequal enforcement. It just falls through the cracks. You have to fix the plate first. And that's the reason the ERA is so important. Intermediate scrutiny being codified is a codification of the cracked plate. The ERA fixes the plate so that nothing falls through the cracks, nothing. Does that mean women never have separate spaces? Of course it doesn't. Even the Supreme Court's recent decision forbidding explicit affirmative action policies in decision-making from colleges and their acceptance decisions, you can't make a race-based decision to pick a certain student. Even that has a really big exception built in. If you read the court's ruling, it says this does not mean that a candidate can't reveal that they're Black and write about their Blackness and their experience as a Black person, and that the school can't take that into account when deciding whether to accept them. So it's just not true that race has become irrelevant as a factor when deciding whether to accept a candidate for admission to a school. It's just as likely that Black candidates and Black applicants are going to be accepted, maybe because they're Black, maybe because of their experiences as Black people, maybe because of how they write so beautifully about their experiences. The point is their Blackness is relevant. And it's allowed to be taken into account, just as a woman's experiences in a locker room with male nudity are allowed to be taken into account when deciding if women need separate spaces, just as a woman's experience with sports and competitions against male bodies will be taken into account when someone has to make a decision about whether the law ought to allow males, biological males, to compete against biological females. The ERA doesn't mean men and women are the same and will be treated the same for all purposes, no exceptions. That's just not what it does. What it does is it makes the government have to work a little harder to justify disparate treatment, to justify discriminatory non-prosecutions and non-arrests of abusive men who target women, to justify the unequal pay problem that has been so pervasive for so long. We don't require the government to work at all, much less work hard at justifying these discriminatory things. We just allow it because it's allowed. Without the ERA, it's perfectly legal. So we don't even complain, much less demand that somebody explain themselves, because it's allowed. Intermediate scrutiny is where it's allowed. And we need to stop saying that it's okay. And that's where the ERA kicks in. It's that simple. The ERA says it's not okay to allow women to be beaten, raped, and killed with impunity. Intermediate scrutiny says it is okay. It's that simple.